Hi everybody, Armine Bazikyan here from Bazikyan Law Group. Today I wanted to speak to you again about property ownership, but this time we're going to focus on a different type of property ownership. We've spoken in previous videos about joint tenancy. This video is going to be part 3, the last part of a 3-part series, and we're going to be discussing tenancy in common as a form of property ownership. Now, a lot of people don't know how they hold title in their property, and this is mainly because you don't really pay attention to it when you're buying the property. You just check the box when escrow sends you the paperwork, and you end up selecting something that somebody recommended to you, whether you're a real estate agent or the escrow agent. But a lot of times people don't know what it means legally for them. What happens when you're gone and you hold property as tenants in common? So let's go through the scenario. Tenants in common legally in California means that there are two people who own the property, and they own the property in either equal shares or unequal shares, meaning they can own the property in whatever percentages they want, and they don't necessarily need to be married individuals. So for example, Sam owns the property as 80% interest holder and Bob owns the property as 20% interest holder. So in that scenario, they're unequal interest holders in the property. So tenancy in common is when two people own the property and it's not joint tenancy, it's not community property with right of survivorship, and they're not a partnership of any type. So it's not a very common form of ownership, but it does exist, and a lot of people choose to select it when they are purchasing a property as an investment with a friend or a family member or someone in their life. And so what does it mean to you when one person dies? So let's say that Sam owns 80% and Bob owns 20%. When Bob passes away, that 20% share that he owned has to be probated, meaning it has to go through the court system before it gets to whoever is going to inherit from Bob. Of course, he can avoid the probate system by creating an estate plan for himself. So for example, if he created a trust and transferred that 20% into the trust, then all of that probate could have been avoided. But let's, for example's sake, say that he didn't create any type of plan. It went through the probate system and it pretty much got stuck there for a year and a half. And so during that time period, the person at the most disadvantage here is Sam, because now he owns 80% of this property and he's very limited as far as what he can do with the property. Now he is communicating with the executor of Bob's estate when it comes to mortgaging the property, remodeling it, doing whatever he needs to do to his investment. It puts him at a very limited scope, and it puts him at an extreme disadvantage with respect to an investment property that he has. So the partner or the other individual is the one that is at the most disadvantage here. There's no right of survivorship, meaning when Bob passes away, it doesn't just automatically go to Sam. It goes through the probate court system, and the probate court will determine who Bob's heirs are and who has the right to receive the property. So once the probate is done, Sam might end up being owners with Bob's son, Bob's wife, whoever it is that the probate court decides. So it's always a good idea to pre-plan what's going to happen, especially if you hold a property as an investment vehicle, if it's an investment tool for you in your overall scheme of assets, because you want to make sure that you and your partner have an understanding as far as who's going to come into the picture when one of you is gone. It could have been avoided had Bob and Sam created their own estate plans. It would have been a very simple process. Each of them would have created a living trust. They would have transferred their portion of the property into their living trust. And then their living trust would have been administered once they passed away. And they could have determined in the trust what they want done with the property, whether they want Sam to have a right of first refusal, meaning they wanted to offer the property to Sam to purchase out. So there's different things you can do. The great thing about a living trust is you can do anything that you desire when it comes to these types of scenarios. So depending on how you hold an asset, in this particular scenario, tenancy in common, it can affect a lot of things as I described to you. So feel free to contact our office and we'll be able to give you more information that's specific to your needs. Our consultations are free, so take advantage of that. See you soon. Bye.